Welcome, my little couch potatoes, to the comfiest courtroom on the internet. I'm your host, Llama, and it's time for dramatic testimony, overruled objections, and absolutely unqualified opinions. So grab your snuggiest blanket, some delicious snacks, and get ready to watch court with your internet besties. This is Couch Court with Llama.
Hello, friends.
Hi.
Look, it's us.
Good morning.
Happy Tuesday.
Yeah, we're back.
I know. Did you have a nice weekend?
I think so. Yeah.
It was okay.
I don't remember.
It was okay.
I'm going to hit that all the time.
What? Oh, your new mic
You
arm?
should being here.
I know. That's the fun part. Well, hello there, 80s music man. Hello. Happy Tuesday. Good morning to you, Angie.
Good morning.
Good
y'all.
morning. Text packet. Good morning. Hope you're doing well. Well, we are here for some more Owens and Greg Gillespie nonsense today. I'm excited about it. How am I feeling? Well, I might have some coughing fits. And if you can hear a little bit of the rattling, I'm sorry. I know that annoys some people, but whatever, you're fine. I'm sure somebody will leave a comment about it.
You're fine. You're fine. I'm the one that's
like,
you're fine.
You're fine. You're right. No, I am feeling good. I don't know what's going on with my voice or the cough that I didn't have when I was sick. I didn't have a cough. And now I'm like, where is this coming from? I don't like it. But other than that, I'm feeling pretty good. I hope you all are doing good too. Hello there, Montana. I'm glad you made it. I don't sound bad. Okay, good.
It's a parting gift.
It is. But yeah, no, I mean, I had a pretty chill weekend. Watched a lot of Marvel with our friends in Discord. Finally finished all of our Robert Hansen scripts. That wraps up this week. Thank God. I'm not going to write anything for like 3 days.
Look at the love letters in our chat.
I really hate listening to the two of you. You hate to say it, don't you? You just hate to say it. I'm just kidding. Well, if you guys haven't yet, make sure you hit the like button. It lets everybody know that we're live. This is where the party's going to be. Who knows what nonsense we're getting into. And subscribe if you haven't. Hit the notification bell because you never miss. That way you don't miss when we go live or drop an episode because we're always doing something around here. This is my last week of having night shows every week, including the day shows. I'm so happy. I'm so happy. That's what happens.
How do you do it?
I don't know. But every time I'm like, you know what, guys, this is going to have to be a multi-part series. Somebody needs to tell me no sometimes.
Well.
I know it's hard. I'm very persuasive.
Persuasive wasn't the word. Stubborn. Stubborn was what I was going for.
Sure.
You're like, no,
Both can be
it
true.
has to be told this way. And I'm like, you know what? You know it better than me. Tell it.
Hello, Ville Marie. Hope you're doing well. Thanks for joining us today. So where we left off last week, because it's been a few days, last Friday was crazy pants of accusations thrown all around. But we left the show with Laura sending a very wild ex parte email to the judge, which is a big no-no. You're not supposed to do that. Anything you send to a judge, guess what? It becomes public information because it has to. And it's just not appropriate to email a judge unless like they email counsel or it's like you don't tell them things. You know, you can like communicate about the process a little bit, like, hey, we've both agreed to, you know, continue, blah, 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 but not the letter she wrote to this judge. And in it was crazy. She accused Greg and his attorneys of conspiring to have her physically and sexually assaulted in New Jersey, which is wild. Because she's already accused them basically of everything she's done, like fraud and making up emails and all sorts of things. And then to be like, yes, they conspired and had that happen. It's crazy, first of all. And then she also reported to the judge that her attorney, Carrie Ramos, withdrew from her case and that she had reported her to the bar with one of the accusations being that she was colluding with the defense. Because there's one thing we're going to learn about Laura is that she loves riding the bar. Well, really any entity. entity that like gives you licenses for things, because she'll do it to
Anybody
Clayton
she can
too.
tattle.
Mhm.
Anybody she can tattle to.
Yeah, which is just, I don't know where she got this idea from, um, but she's gonna start doing it a lot. So she was back to being pro se, and the judge just like made that, or actually I think it was the clerk that filed that, but told everybody about it. And that's kind of where we left off in this story. And we're still in 2022. I think we finish up 2022 today. Yes, we do. So we're getting very, very close to the point where Clayton enters the picture. And so we'll be getting there, not this week, but the week after, which I'm very excited about. Because that's when things, I mean, I don't even see that's when things get crazy, because literally everything has been so crazy. But
I would say it's been pretty crazy up to this point.
it ramps up.
But it sounds like that's when shit really hits the fan.
Yeah, like she really, really ramps up the wowzers thing. So I'm very, very excited about it. Hello, Cheryl. I love that you're all about true crime channels. Me too. Now, if you don't know much about the Laura Owens case, you've got a few episodes. We have an entire playlist of our coverage because we're learning in real time. So if you're new to this whole thing, you can be new with us and have the same reactions and questions and being like, is everybody else seeing this? So we do have a whole playlist there for you guys if you needed to get caught up. Why do women love gruesome murders? Well, probably, I wouldn't say women love it. It's just, we're usually murder victims statistically. So it's probably best to know and, educate yourself and all the reasons to keep you safe, because we're usually the victims the majority of the time. So I wouldn't say it's love. It's having to protect ourselves and be conscious of our surroundings. So I probably wouldn't use that word. Now, anyways.
For me, it's more of, I like to understand why people do it. Like,
yeah. I always think it's weird that people point out it's women, when most of law enforcement are males. Most lawyers are males. Most judges are males. So it's only like, what do you mean women are super into it? It doesn't make any sense when people say that. Sorry, G-Man. I don't mean to like slander your.
I mean, we are, but we are usually the victims too.
Mm-hmm.
So
it's very interesting. And anyway,
but we can do a whole show on that on another day.
We can. So today what we're going to be doing is we're going to be watching 3 Zoom hearings. We tried to do this last time, but the audio was so we did I did my best to boost it up, because Friday I sent Amos, right? I'm like, hey, can you boost this video up for me over the weekend? She was like, sure. And so I reminded her yesterday about it. She sent it to me and I was like, oh, wow, that sounds great. And she did not say to me, Llama, I think you might need a hearing test, because it was the wrong one. That one was perfectly fine. And so like when I opened it this morning, I was like, oh, wait a second, that's not the right one. So I had to go and boost the other one. We'll listen to what we've done our best. I'll have to amp up the audio, but I think we're actually going to be able to listen to it and hear it.
No.
Text packet, what do you have to say? Per AI, women are interested in this because psychological and practical reasons related to safety, empathy.
We are empathy.
And a desire for control in a world where they are disproportionately the victims. Oh my gosh, look at that. Yeah, it makes sense. It makes sense. Plus, I like mysteries. Who doesn't like solving mysteries?
Oh, and all of you know that when you go to the movie theater and it says based on a true story, you're 10 times more interested than if it's some writer's warped fiction.
That's true. Science says so. So
I say so, and that's infinitely better than science.
So today we're going to be watching 3 Zoom court hearings. One's 16 minutes, the other one's an hour, and the other one's 5 minutes. But I don't know if like the hour might have like big breaks in it. I don't know what we're listening to today. I haven't listened to them. So we'll be doing that. And then we do have a few documents to read, which I have some questions about the one, but I'll wait till we get there. So let's talk about where we are now in the docket. because some things happened before this court hearing that were not worth reading the document for. It was basic stuff. And the first one is, remember, Laura's pro se. Well, then she hires, on August 9th, she hires Kyle O'Dwyer from Fortify Legal Services to represent her. So in this year, she's now had 2 lawyers already for Greg Gillespie, Carrie, and now Kyle. And then the next day, and then the next day, August 10th, 2022, Marcus Riesinger, who works for Woodnick Law, says he'll appear on behalf of Greg Gillespie for their August 11th hearing that we're about to have, which is normal. That's not necessarily a replacing attorneys. They could have something else going on, and you're just
hoping
in
for a zaddy appearance.
We will have one. He's in the hour-long one, the one right after this. So, hello, Bruce. Hello. I know more about being pregnant with twins than any dude I play video games with. That's true. That's true.
The more you know.
Titanic 2, the resurfacing, and they're all zombies. Water zombies.
I like it. We need to visit that later.
Is there a ghost or a zombie cruise ship movie? We could probably make that. I really can't be one.
A ton of them.
All right. Well, let's go ahead and get into today. I'm gonna share this little dude out here. There we go. Make sure I'm on the right thing. Okay, so this here is it's not very long. Like I said, it's 16 minutes. I believe this is discussing their motions to dismiss the case in summary judgment. I believe that's what this hearing's about. I didn't write it down, and I should have. I do my best. I do my best. Curse of the Black Pearl was a zombie crew movie. Okay, yeah, fair point. Yeah, that's true. That is a good point, Savage. That's why we keep you around, good sir. All right, so let me boost. Let's see. You guys let me know if this is the one I have problems with. So you guys let me know. Hold on. How is the audio for that?
It's low for me.
It's low for you too? All right. Well, you know what? It's not that important. Let me see just a second. All right. Well, the next one's not. So you know what? We'll just go to the zaddy that you wanted. How about that? We'll just go into the hour one. Oh, that's not what I meant to do. There we go. Also, by the way, this hearing came from Schnitzel Ninja, who has all of the Laura Owens goodies over there. Oh my goodness, they're amazing. So if you want to watch more stuff or get ahead, definitely go subscribe to Schnitzel Ninja, which again, love the names. Wait, your browser has lost connection to your share screen audio. Try sharing your screen again. Okay, so maybe it's a me problem. Okay.
It's a Monday on a Tuesday.
It is. It is. Okay. What is this? The 17th one? Okay, let's try it again. Now, for us, this is kind of like our first time seeing and hearing anybody's voices because I haven't actually watched any of these. So I'm kind of excited about that. Oh, let me like the video.
Look at that epic beard and stash.
I know. So Woodnick is in the bottom left. And then I think the guy on top there, I think that's Laura's lawyer. I don't know. And then the bottom, that's Greg there in the middle. And I don't know who that guy is.
I don't know, but
we'll find out.
He's got that Monopoly mustache.
All right, let's see if the audio works this time, though. Otherwise, I have to close down my Google and come back in. So we don't really want to do that. Hold on just a second.
Good afternoon. We are now on the record in CD 2021.
How's that?
-052893 Owens versus Gillespie. This is the time set for
Can you hear it?
Argument
Buffy?
on the
I can. Kind of. But the chat needs to let us know if they can.
Pleadings on February the 15th after our continuance from last week. Can I have your appearances, please? For
Yeah.
plaintiff?
Yes, Kyle O'Dwyer on behalf of plaintiff Laura Owens, who it appears is also in attendance for today.
All right, chat, can you hear it? It's super quiet. Why? Fuck me. Okay. It sounds good on my end, but damn. Okay, let's try this again. Boosted it. Let me know.
Thank you. Welcome. And for defense?
Good afternoon, Your Honor. Marcus Reisinger on behalf of defendant Greg Gillespie. Greg Woodnick is also in attendance, as is Mr. Gillespie himself.
All right, thank you. Welcome.
Okay, how was that? And I can hear okay. Well, shit. Okay. All right. Some people, all right.
It's just very low. I would have to like everybody stop talking so I could hear it and push my earbuds in really.
This is not the one that you did, Amos. That was one that I didn't think I needed you to boost, but well, I don't know what to do about it. Better, but not great. Okay, well, it's better. Okay. Does this have subtitles? Maybe that might. Okay. We got subtitles, so that helps. All right, we're just gonna play it. We're just gonna play it. Buffy, because I had to boost it. Don't if you want to talk, we'll just pause it and then I'll lower the volume because otherwise we sound, you know how it sounds because you've listened.
Sounds like our viewers might thank you for that instruction.
Yes.
Don't talk, Buffy.
All right. Okay. All right. Oh, look who popped backstage. All right.
All right, counsel, any preliminary issues we need to take up before we get started? The court has read the briefs of the parties, of course. We have the time divided equally between you. And we'll say that you don't need to use the full half hour that you've been provided. That's a question that the court often gets. Don't feel like you have to fill up a half hour if you don't need a half hour. But I found that half hour total for both sides tends to be a little short, and I don't want to stress people out. So I try and build in a little bit of a question there. Any preliminary issues you need to talk about from either side? For plaintiff?
No, thank you, Your Honor.
No? All right. How about for defendant?
No, Your Honor.
Okay. All right. Well, with that, we'll just get right into it. It is defendant's motion, which means that he'll go first. So his attorney will argue first, and then we'll hear from plaintiff's counsel. And then if defense counsel has saved any time, and I'll be keeping time as well. So if you need a time check, just let me know. But if defense counsel elects to reserve some time, then he'll get the last word on the motion by way of rebuttal argument because it is his motion. So that's how we'll proceed this afternoon. All right. So we'll look forward to hearing what you have to say. On behalf of defendant, go ahead.
Thank you, Your Honor. I will attempt to reserve 5 or 10 minutes for rebuttal, and I'll try to keep my own time as well. I'm going to start. I may go a little bit out of order from the way the arguments are presented in the motion, but I'd like to start with the pleadings themselves, because that seems like the straightest line to the resolution we're seeking here. On its face, the complaint alleges various acts and conversations that Mr. Gillespie and Ms. Owens had. I'm assuming for the sake of the standard on a motion for judgment on the pleadings that all of these well-pleaded facts are true, certainly not admitted, but are true for purposes of the motion. If we do that, we find that the acts that Mr. Gillespie allegedly engaged in don't qualify for the relief that Ms. Owens is seeking under Title 36-2153. The reason for that is the statute says a person shall not in any way intimidate or coerce another person to obtain an abortion. Intimidation and coercion are terms that are not defined in the statute or really readily defined anywhere in Arizona law. But in the motion, I've pointed out 2 places where those terms appear in Title 13. And in both of those instances, they speak to not just persuasive speech, but truly intimidating and coercive conduct, such as threatening violence or actually engaging in acts of violence to cause another person to do something. The other example in Title 13 relates to sex trafficking. And again, the conduct that's prescribed there is actively threatening someone's safety or their legal standing or withholding a substance from them on which they rely physically. So all of these things are conduct more than just speech. We can imagine a scenario in which a person threatens someone else and says, "You're going to obtain an abortion today, I'm going to drive you there, and if you don't, I will hurt you." And certainly that would be intimidating or coercive. But that's not what's alleged in the complaint. In the complaint, there are many allegations relating to going on a trip, pursuing a long-term relationship, getting married, meeting with someone's family, etc. None of these are threats of harm. None of these are coercive in the sense that those terms are used in Title 13. The alleged behavior that seems closest to potentially being coercive is actually a promise to do something good, not something harmful like the other examples. The only thing that, again, assuming all the well-pleaded facts are true and reading them in the light most favorable to the plaintiff, there is this allegation that Mr. Gillespie threatened to, quote, go public with the abortion. But as stated in the complaint, if that occurred, it occurred after it was already completed. So that behavior, that conduct, or that comment must be excluded temporarily because it couldn't have been intimidating or coercive prior to the abortion taking place. For that reason, the complaint itself simply fails to state a claim for which the court can grant relief, assuming all of its well-pleaded facts are true. Next, we've questioned whether Title 36, Section 2153 actually creates a cause of action against an individual. The statute is long and sort of meanders through various different topics, but the overwhelming majority of these subsections speak to acts and requirements of abortion providers, medical providers. The statute requires certain notice to be given and a timeline for that to occur, ways of documenting informed consent, certain information that a provider must give to someone before performing an abortion. None of those things speak to the conduct of a private individual. The only section that arguably could, which is this very broad subsection G, simply says a person shall not intimidate or coerce in any way any person to obtain an abortion. But then that section goes on and talks about a parent or a guardian coercing a minor child to obtain an abortion, and what occurs if the family denies financial support to the child. So even reading just that section in a vacuum without considering the other subsections of the statute suggests that the kind of conduct that's prohibited is not something that Mr. Gillespie could have engaged in. Further down in the statute, there's a mention in subsection L of a civil section filed pursuant to subsection K. But subsection K references an abortion being performed without informed consent as required by this section. So again, the only section of the statute which appears that it could create a private cause of action against an individual is limited by the language of the statute to a person who's performed an abortion without informed consent. And then the statute defines in various ways what that consent looks like and what things need to be done. But none of these are conduct that a private individual could engage in, unless I guess they performed the abortion themselves, but that's not what was alleged here. So given the pleading and the conduct that's been alleged and the language of the statute itself, there is no claim here for which the court can grant relief for what I'll call abortion coercion as shorthand, because the claim itself is not really defined in the statute.
Let me pause this for just a second. Hold on. By the way, I thought that was a very good argument. Very good points made of, so they're arguing, we read the document about this, about, you know, abortion coercion and the statute and what it reads and the unconstitutionality of words of Greg being like, oh, I don't want the baby, get rid of the baby or whatever, and whether or not that's unconstitutional because that's not the same. Like, where do we draw that line? Because the statute was it was very vague about like everything. So that must be what this is about. Also, hello, everybody coming in. Yes, they all look alike. That is weird. Also, Greg, if you're watching, great hair, by the way. Very nice, luxurious hair. So, oh, I'm sorry, am I super loud? Okay, we'll go back.
Moving on and assuming for the sake of argument that there is a cause of action against a private individual under these circumstances, we've alleged that it is impossible for the court to afford complete relief with the existing parties. And the reason for that is because the statute clearly requires conduct of a medical provider who conducts an abortion, but no such provider has been joined here. And even if we read the complaint and assume all of the facts true, there was no abortion procedure performed here by a third-party medical provider. The acts alleged that caused an abortion under the complaint, assuming the facts are true, were acts by Ms. Owens herself. All of the acts, most of the acts, as described in the motion, occurred outside of Mr. Gillespie's presence. They, according to the complaint, were done for.
All right, we will go ahead and call the case then.
Hold on. What are you doing? Oh. Sorry.
And we are now on the record in CD 2021.
Amy, what are you doing?
052.
Are you playing it now or am I? Just so I know. Oh, it'd be nice if you read the... Oh, you didn't want that to happen? Okay, sorry. In a momento.
Because she wanted to maintain a relationship with him. And promising to do something, even if the promise is known to be false at the time it's made, is not intimidating or coercing. You could argue that it's bribery or some kind of fraud, but that's not what's been alleged here, and we're certainly not admitting that. But again, there's a categorical difference between offering to do something good and threatening to do something bad and its coercive effect on a person. In the statute, the language that's used suggests we're talking about doing something bad, not promising something. If a claim exists, then the provider themselves must be joined. If there is a provider here, then arguably it would be the person who provided the drugs that Ms. Owens used to perform the abortion. We don't know who that person is. We certainly can't join them ourselves, nor is it the defense's obligation to do so. But the claim fails because the court cannot afford relief under this statute for this claim without including the provider, because that's the person who is required to obtain informed consent. That is the person who's required to document that informed consent. And arguably, Mr. Gillespie may be indemnified if there were a claim by the person who conducted this abortion without informed consent, because the duty here to do that is on the person who performs the abortion, which is not Mr. Gillespie, and it's not alleged that he's the one who performed it. All of these arguments thus far for improper joinder and the judgment on the pleadings are really limited to the pleadings themselves.
Okay. Just a second. Turn down the volume. So the lovely Amos has made the sound better on her version. So that way we're not blaring. So we're going to switch over to hers real quick.
And then Owens versus Gillespie.
You need it on 11 minutes, Amy. Yeah, I wonder if that's why the lawyer left.
We're professionals, guys.
We are.
It's not alleged that he's the one who performed it.
There we go. How's that for everybody?
All of these arguments thus far for improper joinder and the judgment on the pleadings are really limited to the pleadings themselves, Your Honor. The claims I'm going to
that's Greg Laney.
Motion now that I'm going to talk about is relating to the constitutionality of the statute. So we're taking a little bit of a different approach.
All right, can we just pause there for a moment? So looking at subsection K of the statute, when I say the statute, I'm talking, of course, about 36-2153.
Yes.
So for shorthand, the court will just refer to it as the statute. So when we look at subsection K, the very first clause in it says, in addition to other remedies available under the common or statutory law of this state. So wouldn't that defeat some of your argument about having to satisfy numbers 1 through 3 of subsection K?
I don't think so, Your Honor, and hopefully I'm
Okay.
understanding your question correctly, but there's another claim in the complaint for intentional infliction of emotional distress. That could arguably be one of these common law remedies available that we're not moving to dismiss based on the pleadings. We may move for summary judgment on that issue if Ms. Owens complies with her disclosure requirements or doesn't. But this statute, this subsection K, seems really just to be limiting a claim for a violation of this specific section of Title 36.
Okay.
I want to hear what her lawyer says. What you got for us, Kyle?
And the court agrees with you that the definitions in this statutory scheme are obviously not inclusive. So if we look at 36-2151, which is entitled definitions, there certainly isn't any definition of intimidation, of coercion, or really anything similar
For
to
Greg's
that
case,
that the court could find.
Her second one
So
far.
that was not helpful as far as interpreting the term intimidate or coerce as used in subsection G. But it does go on to talk, and perhaps this will, it sounds like, go to what you're arguing about next, which is about the constitutionality of the statute itself. But by using the phrase "in any way," isn't the legislature signaling that it doesn't wish to be limited by perhaps what was included in Title 13? And it sounds like perhaps you can fold that into your comments about constitutionality, but go ahead.
I will, Your Honor, and just as a preliminary point, in order to challenge the constitutionality of a statute, as the court knows, we're required to provide notice to certain government officials. We have done that. I noticed after the last hearing that we hadn't filed those affidavits of service, but they have been filed and they're on the ECR now.
Yes, we saw that. Thank you.
And so, yes, I believe that the language of the statute has numerous flaws, which we've pointed out. But the one you've just highlighted, Your Honor, is the one that really creates the biggest constitutional problem, and that's intimidate or coerce in any way any person. So we have two very broad categories here. One is the target of the intimidation or coercion could be anyone. There's nothing limiting this to a specific set of circumstances, a relationship between the two people, whether they spoke face to face, whether the speaker intended to reach that individual or even knew that that individual was pregnant. Those things, as I discussed in the motion, are all incredibly broad and vague. But then this "in any way" language in the statute, again, I believe that the legislature's intent was, as Your Honor has stated, to not limit intimidation or coercion to a specific definition or a specific set of words or conduct. But by using such broad language, the legislature has necessarily swept in protected conduct. So, for example, a person could make a comment to another person, I believe bringing a child into the world which was not planned or which was not in wedlock is unethical. Well, that could be coercive or intimidating depending on the relationship between the two people or how it's said. But clearly that's protected speech. It's really just an expression of a philosophical standpoint. It's not the kind of conduct or aggressive language that we see in the Title 13 definitions of intimidation or coercion. And so the legislature may have intended to broaden those definitions by saying coercion or intimidation in any way qualifies as actionable under this statute. But just because the legislature intends to do that doesn't mean it's permissible under the law. There's plenty of case law suggesting that certain kinds of speech and behaviors are protected. Even after the recent Dobbs decision, things like the zone of privacy are still intact based on the language used in that decision. And so this language here is simply too broad for an individual to know, one, what kind of conduct is actually permitted or actually prohibited by the statute. Two, what kinds of remedies or what kinds of penalties may exist for doing so. I'll touch on that point again in a second. But also what kinds of speech is permitted and which is not. And so in a way, the statute also acts as a form of prior restraint based on the content of one's speech. So it doesn't say that there can't be a conversation within a specific sort of set of parameters. The statute could say that there can't be a broad discussion of abortion in a way that incites a riot, for example, or in the context of physical violence or intimidation or coercion. But it doesn't. It says, shall not intimidate in any way any person. So really, it's all sorts of speech. And it's almost impossible to know where the line is, where you've crossed
very fair points.
Suggesting or persuading a person and into intimidating or coercing. And nothing in the statute does or even could prohibit suggesting or persuading a person to do these things, because clearly that would be protected speech. Only when the speech is either accompanied by conduct or is so severe in itself that it crosses over that line into intimidation or coercion can the legislature bar that from occurring.
Okay. I'll be honest, I don't understand how this case isn't dropped at this point, but it doesn't. Spoilers.
Sorry, I skipped around a bit in the direction I was going to head here, so let me collect myself briefly.
Sure. Take your time.
That's a good point, Buffy.
Okay, so I was going to circle back around into the zone of privacy. The statute is concerning because it sweeps up protected speech. And the reason that we know some of this speech is protected is because the U.S. Supreme Court has given us certain circumstances where conversations between private individuals are given heightened protection as speech that involves a fundamental right or is within the zone of privacy set forth in the Griswold versus Connecticut decision. In that decision, the court said the First Amendment has a penumbra where privacy is protected from governmental intrusion. And this statute certainly appears to invade that space, because a person having a private conversation with their spouse or their significant other about an abortion goes directly to the kinds of relationships and the kinds of contexts in which this zone of privacy grants heightened protection to that form of speech. Things like a decision whether to bear or beget a child, which is a fundamental right under the U.S. Constitution. If that is the case, and it seems to be, then this prohibition against speech would have to overcome strict scrutiny, meaning that the government would have to have a compelling interest in regulating the speech, and must also do so in a way that's narrowly tailored just to achieve that interest and not sweep up any more protected speech than necessary. So arguably, had the statute read, a person shall not intimidate or coerce another person to obtain an abortion, and didn't have this broad in any way language, it might survive strict scrutiny because there it's more narrowly tailored. But here we have arguably, and I'll concede for the sake of argument, a compelling interest to try to protect potential life. But the narrow tailoring is certainly missing here. This is about the broadest tailoring you can possibly imagine. The only way it could be broader is if the statute said a person shall not intimidate, coerce, or persuade, or suggest. There could have been additional forms of conversation that it sweeps in, but the language as it's written is extremely broad and clearly invades that zone of privacy, that sphere where individuals are permitted to communicate with one another in order to exercise and contour their fundamental rights in the relationship between them. And so to the extent that this statute acts as a prior restraint on that speech, and in this case specifically as applied, is it being attempted to be used as a cause of action for non-intimidating, non-coercive speech, it is unconstitutionally broad and vague. There's no way that Mr. Gillespie could have known what conduct was permitted or that this conduct specifically was prohibited if we read the statute to include what is alleged in the complaint. Your Honor, if you have additional questions at this time, I'd be happy to address them, but otherwise I will reserve the balance for rebuttal.
All right.
What do you got to say, Kyle?
At this time, the court doesn't have further questions. We'll hear from plaintiff's counsel.
It's true.
Thank you, Your Honor. Your Honor, I would like to start where the defense started with the allegations in the complaint and whether under 12b6 that is sufficient.
How's this guy going to say this with a straight
cause
face?
of action here. In reviewing the complaint, the specific paragraphs and the attachments to it, it is sufficient, Your Honor, to state a cause of action. In looking at, for example, paragraph 11, the allegation is that Mr. Gillespie said he did not want a bastard child. He would have no involvement in its life, nor pay child support. So
How many men say that,
any
though?
kind of financial support for the child. Paragraph 14, he would refuse to contribute to the relationship until she terminated the pregnancy. Paragraph 35, he threatened to call law enforcement on her if she hesitated to get an abortion. If you look at one of the attachments to the complaint, when I was reviewing the filed documents in the court's file, it was from part 2, I believe page 7 on the right side. And in a text message, it said, by Mr. Gillespie, if I don't get a say, then you don't get money from me. And he made it clear in that context that he was in favor of abortion. So these statements, Your Honor, do constitute coercion. Now, defendant's counsel is correct. There is no definition in the statute of intimidation or coercion. Courts have long held that even if there is not a definition,
I know, what an a-hole.
Then the court looks to what is the normal definition of these phrases in normal life. And so if you look at, for example, the Merriam-Webster dictionary, which is often cited,
Sir.
the definition of coercion is the use of express or implied threats of violence or reprisal, such as discharge from employment or other intimidating behavior that
Which
puts
didn't
the
she call his
person
job or
in
something?
fear of the consequences in order to compel that person to act against his or her will.
Literally
Now,
what she did to him.
I do want to be clear that while my colleague has cited various criminal statutes as what obviously would qualify as intimidation or coercion, that is obviously the highest and most strict standard. This is a civil case. We're not in a criminal case. And so the standards from dictionary
Foreshadowing.
and other items that are common to people do apply, as well as these criminal standards.
Yes, Bruce, you have.
And one
sue you.
case that I would cite to Your Honor, as far as when lack of a dictionary definition does not
She's not, and I don't know
compel
why.
the
Probably.
I guess,
so hi.
statute to be void for vagueness or otherwise unenforceable is Franklin v. Clement, 240 Arizona 587. And in that case, Your Honor, the court specifically discussed the void for vagueness doctrine, but it goes on to state that.
Straight to jail right away.
Find it.
You're out of here.
1 second here, Your Honor. As long as a statute allows a person of ordinary intelligence to reasonably understand what is prohibited, it will not be considered unconstitutionally vague, even if it is susceptible of different interpretations. And the court was discussing what under the influence means in that case, which was not defined.
What? Why are we reaching
and
out
so
to that?
The fact that it's not specifically defined in the statute is not fatal. But, Your Honor, the specific allegations in the complaint are enough for the court, as the court held in its initial 12B6 order regarding the first motion to dismiss, for a jury to find that believing and taking all inferences in favor of the allegations of the complaint, a jury could find that it is proved. Now, as far as the statute and whether or not the statute allows a claim for under paragraph G, Your Honor, I believe that subsection K or paragraph K, however you would like to refer to it, of the statute, and of course I'm referring to the statute in the same way the court did. I think another key phrase, other than the one that the court pointed out, is any of the following may file a civil action to obtain appropriate relief for a violation of this section. And it doesn't refer to subsection A, paragraph A alone. It refers to this section. And so that includes paragraph G, which is a person, you know. It includes paragraph I, which also indicates a person, which that allegation is not present, Your Honor, but to the extent that the defense indicated that this action could only be brought against a physician, it's clear that throughout the statute it references what a physician cannot do, what an individual cannot do in subsection E, what a person cannot do in subsection F, G, and I, and what an abortion clinic shall do in subsection H. So when you look at K and that it is for a relief of this section, not specific to any certain subsection, that has to include all of these, including G. And one of the individuals that is able to bring an action is a woman on whom an abortion has been performed without her informed consent. Now, another issue of statutory interpretation that I think is important for the court, because as the court knows, the reason for statutory interpretation is to effectuate the intent of the legislature, as indicated throughout the statute and not specifically only one subsection, is so looking at the different types of individuals specifically listed.
You each get 0.02
a woman, a father who is married, not just any father, but who is also married to the woman, and then a maternal grandparent. I find it interesting, Your Honor, that they can bring an action for a violation of this section, but it only references informed consent with regards to the woman's ability to bring an action. In number 2, the father of the unborn child, there is absolutely nothing in that says that it is only if there was informed consent. And one thing that the legislature and another canon of statutory interpretation is that we can't interpret statutes to that would give an absurd result. And so if the court were to find that there was no ability to bring a cause of action in this case because the woman's ability is limited to a condition precedent that there was not informed consent.
Laura's just so
But a
ridiculous, you guys.
father could bring an action under G that is married.
Exactly, Phil.
It goes to an absurd result, Your Honor. And so that's why in looking at the interpretation and looking at the broad public policy of this statute, which is to protect a woman's right to be informed about her decision and not to be coerced into making that decision.
Why do I feel
limiting
like
her right to bring a
Zaddy
cause of
Greg
action
just has like a smirk on his face the whole
to
time?
only a specific set of circumstances,
Hilarious.
whereas the father has an unfettered right, a married father, would lead to an absurd result. And I think if you continue to look at subsection L, and I know I'm going into a lot of detail because
I got nothing.
obviously I wasn't able to file a response here, and I want to make sure that all the points are covered, Your Honor.
She's gonna
But
ramble.
looking at
all I
subsection
got.
L, I think also lends to that interpretation that this is not only against physicians, this is against any person, just like Mr. Gillespie. And if you look at subsection L1, again, you're able to bring a cause of action for money damages for all psychological, emotional, and physical injuries resulting from the violation of this section. Not just the violation
What's
of
going on with that guy's
subsection
face?
A for informed consent, but a violation of this section in whole.
Bottom jaw
And so if
dislocates there.
the court were to interpret this contract or the statute, pardon me, as precluding this claim, I think that would be against the public policy in which this was enacted. In that vein, the motion cited the doctrine of expressio unius as, and I might be butchering that pronunciation, Your Honor, but as that it should be applied in this case to prohibit this claim. One thing that was not mentioned in that is this doctrine is not to be applied where its application contradicts the general meaning of the statute or state public policy. And so my client's position is that if the court were to apply it to limit the claim herein, as the defendants are alleging, it would contradict the state's public policy here to protect a woman's right to make this decision without
It doesn't make any sense to me either,
to be
Bill.
informed about it. And this language comes directly from Southwest Iron and Steel Industries, Inc. v. State, 123 Arizona 78, which was cited in the motion by the defendants.
So this guy was hired on August 9th. This
And
hearing is
so for
August
those
17th.
reasons,
He doesn't
Your
know
Honor,
shit about this case yet.
I believe the legislature specifically
Oh, no.
intended to allow this type of a claim to go forward.
Well, so your argument, counsel, is that your client
Your banjo Morse
is
code.
not one of the three categories of people under subsection K1, 2, or 3, but that essentially the legislature erred when it had included the phrase without her informed consent in subsection K1. Is that accurate?
Let me clarify that, Your Honor. Thank you for that
Please do,
question.
because it does make sense for this case.
My position is that within this doctrine, right, within K1, a woman on whom an abortion has been performed without her informed consent is the fact that there has to be consent, period. And if you look at this the heading of this section is informed consent. And then it goes on to say requirements, information, website, signage, violation, civil relief. But at a base level, my client didn't give consent to the abortion because it was overcome by
You and I are like,
the
sir.
coercion of the defendant. And so that is how the court should interpret that specific provision in K1 in finding that my client is entitled to bring the cause of action as an individual under K1. And again, looking at the absurdity of it,
That's
if
a word.
she wasn't able to, as a single woman, so there was no father of the unborn child that was married to the mother at the time she received the abortion. So the legislature didn't intend to penalize single women under this statute and leave them out of any ability to bring a violation of subsection G or I or subsection E, which, in looking at the motion, Your Honor, the defendants indicated that Mr. Gillespie could be liable for, I believe it was 36-2155, which is obviously a separate section, but it is the exact same language as under E. The very same phrase, an individual who is not a physician shall not perform a surgical abortion. It's just in a separate section, and that separate section does not contain a specific civil cause of action. Does that answer your question, Your Honor?
Yes, thank you.
I don't know how she hasn't gotten those charges, but.
Well, with that, Your Honor, I'd like to move towards the constitutionality piece of the motion. The first thing I think that
there's a lot of Latin in the legal world.
The courts have long held there is a strong presumption that a statute is constitutional. So the defendants start on an uphill battle in bringing an action claiming that this statute is unconstitutional. There is a presumption that requires the challenging party to establish that unconstitutionality, and any doubts are resolved in favor of upholding the statute. And that is, it's throughout various cases, Your Honor. If there is a specific case I'd cite to, it'd be Ramirez v. Health Partners of Southern Arizona, 193 Arizona 325.
Love it.
But getting to the void for vagueness argument, as I mentioned earlier, the test is whether the statute gives a reasonable person of ordinary intelligence a reasonable opportunity to know what is prohibited. And so just because it might be hard to tell exactly what side of the line some speech is on, does not mean that the statute
she didn't, Lainey. You're not wrong.
vague, unconstitutionally vague.
You are not wrong. Again, I don't know how she's coerced.
And another
took this several times.
General rule of law that courts are to apply is courts are to interpret these statutes in a manner that is constitutional. So when
remember, they went on 2 dates.
The motion tries to intimate that this statute is too overbroad because it really is according to the subjective feeling of the person, whether or not they were intimidated or whether or not they were coerced. That's not what the statute says. And that's not the vein that the court should interpret it. Because that's not the way that a reasonable person of ordinary intelligence would interpret it, because that's adding words to the statute. That would be saying that the statute indicated a person shall not make another person feel as if they are intimidated or coerced. And that's definitely not what this statute says.
Because he said he would be with her forever.
And so, Your Honor, the void for vagueness argument should be denied. Intimidate, coerce are terms that are used throughout the statutes in Arizona, Department of Transportation statutes, various places, and are common terms that have been used for years. So the case Franklin v. Clement talked about, as I indicated, what under the influence means. And the court indicated that under the influence has a commonly understood meaning. And although different people may evaluate under the influence in different ways, that by itself does not make it void for vagueness.
But then why would we define intimidation
so
and coercion in other parts?
All right, I just want to ask you, though, it's kind of the same question that I asked opposing counsel, but just turned towards you. Here, though, on subsection G, we have shall not intimidate or coerce in any way any person, which seems a little bit broader than just your common. If we look it up in the dictionary, we're talking about in any way. So it's somewhat broader, I think, than the limited under the influence, I think, as a kind of a common parlance understanding. Here we have intimidate or coerce in any way. So what's your response to a broadness concern there?
Sure, thank you, Your Honor. I believe that so the start of that goes back to, well, what is in any way modifying? And so intimidating or coercing. So I think that goes to statements, behavior, threats. How are you performing it? I think the legislature wanted to be sure that
it's been the defense's argument.
Just threats, statements to somebody. This is also actions. So if you, for example, if someone leans into you quickly, that could be seen as threatening while you're saying something.
Did you guys both threaten there?
To get an
and I'm
abortion.
staring.
But I think the legislature just didn't want to confine it to only words or only
if you're threatened by that, get a life.
Threats of physical harm, only threats of physical violence, things like
so
that.
Let me ask you then. Back in a past life, when I was a federal prosecutor, I used to prosecute bank robbery, and we had a guy who, I promise I'm getting to my point quickly here. We had a bank robber who was convicted of bank robbery, and under the federal bank robbery statutes, it defined robbery as intimidating someone into giving you money. So his second time around, he was convicted. He goes back out, and he goes to a bank, and this time he goes into the bank, and he says, "Please," and he smiles at the teller, and the teller gives him the money. So you can guess what his defense is. I didn't intimidate anybody.
I said, please.
I walked in, I asked for the money, and they gave it to me. It wasn't robbery. So in that case, the court struggled with what is intimidation? How do we deal with it? And similarly in this context, so if someone talks to another individual who may or may not be pregnant and says,
may or may not be. I like what she did there.
Have you thought about getting an abortion? It's a question. Have you thought about going through with it? And they smile and they're polite. Are they intimidating? Are they coercing? And how do we answer that in the context of this statute?
Sure. Thank you, Your Honor. I think it goes back to that reasonable person standard, right? And as I indicated, a court is to interpret a statute such that it is constitutional.
I don't think we're dealing with a reasonable person.
No, that specific conduct it would be unconstitutional if that were to be applied and that were to be a violation. So a court can set that aside and focus on the specific conduct that would be a violation of the statute. And so, for example, the court indicated that a person who may or may not be pregnant, the question is whether they could be intimidated or coerced to obtain an abortion. I think that
well, if they're not pregnant, why does that even matter?
Obtain an abortion should be construed such that, well, they're pregnant, because it wouldn't matter if they are not pregnant, if it was conduct or statements, intimidating or coercion conduct or statements to a male. I think the court can interpret it such that, well, that can't violate this statute because they are not pregnant. And the conduct has to specifically be to obtain an abortion. So
let me flip it around. What if a pregnant, there's a couple and they're pregnant, and the woman who's pregnant is the one who is intimidating or coercing the man to get an abortion. So she doesn't want to carry the pregnancy, but he does.
Yeah,
so
then what, Kyle?
Like he would have a cause of action under the statute. Is that right?
I don't believe so, Your Honor, because it would have to be the way I read it, and the way I think the court should interpret it, right? Because the court's supposed to interpret it such that it's constitutional, is that the person has to be pregnant in order to for someone to coerce them or intimidate them to obtain an abortion.
They have to be pregnant.
So, for example,
thank you, Kyle.
The motion indicated that, well, you could do that to yourself and potentially have a cause of action. One thing I think that goes without that should be mentioned is this isn't a criminal statute, right? So you'd have to get damages. So if you intimidated yourself, you can't have damages or sue yourself. That's not a cause of action. And so that can be set aside.
There was somebody who did sue themselves, a prisoner, for getting put in prison.
Assuming they're not pregnant. And I know that conversations about that come up sometimes these days. But so coercing or intimidating them to obtain an abortion, I think needs to be construed by the court such that that individual that is the victim of it is pregnant and would be the one to obtain an abortion themselves.
Okay. Thank you.
Thank you, Your Honor. The final thing that I would mention, Your Honor, is as far as joining the claim of failure to join a necessary party, there is nothing in this lawsuit that prohibits my client. A claim against the physician and a claim against Mr. Gillespie are totally separate. The statutes are separate. The damages are separate. There would be nothing, and I'm not saying that this happened at all in any way, if there was a settlement. Does that mean that we have to bring him into this action because without the physician's presence, Mr. Gillespie, there can't be complete relief? Well, they're separate causes of action. And so the physician, whether it's a he or a she, and I'm totally unaware of who it is, but they are not necessary for my client to obtain relief against Mr. Gillespie because the claims against him are not the claims against the physician.
I thought it was like informed consent was the issue here.
My client would ask the court to deny the motion to dismiss.
All right, thank you. Just a moment here. Let me look at my notes and see if there's any other questions that the court may have.
Well, that's the problem, Minnie, right? Is what does forcibly mean? What does intimidating mean? Because I'm sorry, but if it's just your opinion, then everybody's entitled to their own opinion, right? And that's the line that they're arguing here is...
You answered the question, but I just want to make sure I understand.
What is intimidation
so under subsection B,
versus
it says a person shall not intimidate or coerce in any way
argument.
Any person to obtain an abortion. So the to obtain an abortion, your argument is that means that the hearer of the coercive or intimidating speech, or you said it could be an action because it's in any way, that the victim, if you will, it needs to be pregnant.
That's correct, Your Honor.
Okay. And
so
that
you
is
need to be
the phrase to obtain an abortion.
Correct, Your Honor.
It's very important because she's not
So
or wasn't.
could somebody so under your interpretation of the statute, then you could not have a situation then where, say you have a pregnant couple and say the father has an aunt and the aunt is really coming down on the father. This mom needs to have an abortion. That needs to happen. She never talks to the mom. She only talks to the dad. Does the dad have a right of action under G? Earlier you said no. Just want to make sure I understand, because under G it says in any way. Could he sue his aunt?
I don't believe that there would be a right to a cause of action for that, Your Honor.
Okay.
I think
And
that
if-
would be outside of the scope and outside of what the legislature was looking to do here with
It's not a
this
well-written statute.
Okay.
At all.
And that is because he couldn't himself obtain an abortion? Is that your basis for that?
Yes, Your Honor.
Okay. All right. Thank you. All right, so we'll hear if there's any rebuttal or reply. I see that you have 10 minutes remaining.
Right,
Thank you, Your
Manny,
Honor. I'm
right?
going
Like
to
that's a
start
little.
with the reference made to 36-2155. I think Mr. O'Dwyer said that we'd envisioned that there could have been a claim against Mr. Gillespie for a violation of that statute, but that statute pertains only to a surgical abortion, which is not alleged, and that's one of the few terms in this statutory scheme that actually has been defined for us. So clearly that's just not the case. I'm going to go back to the vagueness point because I think the court stumbled on, and Mr. O'Dwyer discussed, kind of an interesting quirk in this statute. If you look at subsections K1 and K2, if we're going to read the statute exactly as it's written, which seems to be what Mr. O'Dwyer would ask the court to do, then there is a difference between a woman on whom an abortion has been performed and the father of an unborn child if he was married to the mother at the time she received the abortion. Because K1 specifically says a woman on whom an abortion has been performed without her informed consent may file a civil action to obtain relief. And then it doesn't say anything about informed consent in K2. I don't think the court can read that section without the informed consent component, without making this entire statute superfluous, absurd, insert adjective here. The abortion in K2, it means an abortion without informed consent. If an abortion is performed with informed consent, then certainly the father of the unborn child could not sue the person who conducted it. Nothing in the statute suggests that the informed consent must also come from the father of the child or the grandparent of a child if the mother was under 18. The operative language in this statute is that informed consent. That's what the entire statutory scheme is built around. And if you look in the rest of Title 36, informed consent is referenced even in the general provision title of 2153, 2158, 2156. So this common thread of needing informed consent exists throughout this entire scheme. And so again, the statute, when read through this lens of informed consent, imposes numerous duties on the person who provides or conducts the abortion. It says an abortion shall not be performed or induced without the voluntary and informed consent of the woman on whom the abortion is to be performed. That's in subsection A of 2153. And then I'm not going to count them on the record, but there are over a dozen, maybe 24 different provisions, all relating to the duties of the person who performs the abortion. And then if you go to the definition statute, the Surgical abortion requires termination of a clinically diagnosable pregnancy. Medical abortion is the use of a medication, drug, or other substance. Both of those things require a medical provider. They're the one who has the duty to ensure that informed consent is given. And so reading the statute to have a couple dozen provisions about medical providers and informed consent and all the various requirements and duties they have and some of the consequences that they may face for failing to do so, such as J, a physician who knowingly violates the section, commits an act of unprofessional conduct. But then reading only subsection G, not to apply to that circumstance, or not only to that circumstance, but to broadly apply to any private individual doesn't make sense.
With Woodnick.
We're now reading one sentence,
but this is kind of like his specialty, so that's why he's doing the argument.
And meaning and purpose and policy basis than the rest of it. That's an absurd reading. Conversely, the court could read that subsection only to apply to a person who performs the abortion without informed consent and avoid that problem.
She says the proof is her P test. And that's all the evidence she has of any record of anything, which doesn't mean anything.
Language which the court pointed out during Mr. O'Dwyer's presentation. Mr. O'Dwyer responded that in any way is intended to modify, intimidate, or coerce, and brought in what kind of conduct or speech is intimidation or coercion. If that was the case, then the legislature should simply have wrote, a person shall not intimidate or coerce any person to obtain an abortion. Because intimidate and coerce are not defined in the statutory scheme, that would be sufficiently broad on its own. But looping in this in any way language, which is far more broad, as the court has pointed out, brings in all sorts of unique problems that I've pointed out create First Amendment issues. Coercion or intimidation in any way. Does the person speaking need to know that the person who receives the abortion heard them? Do they need to have any kind of relationship with that person? If it's a reasonable person standard, which doesn't appear in the statute, then the answer I think would be no. But the statute is written to incorporate any kind of intimidation or coercion. So a public figure could go on television or during a political debate, for example, and say, I believe that any person who bears a child outside of wedlock is committing child abuse and they should instead get abortions. Certainly some listeners would find that intimidating because it's coming from a public figure, possibly even coercive if they think that public figure carries the force of law, but that would clearly be protected speech. I don't think that's questionable or even an issue for discussion. So we can't read the language of the statute to incorporate any kind of intimidation or coercion without doing damage to the First Amendment and to protected speech. Alternatively, the court can read that section as unconstitutional if applied in that manner, and then we don't have the issue.
Fair points.
Lastly, I'd like to go back to the complaint itself, because Mr. O'Dwyer pointed out a couple of sections that he felt are intimidating or coercive. One of those was that Mr. Gillespie said he did not want a bastard child and would have no involvement in the life or pay child support. That's in section 11 of the complaint. But then in section 14 of the complaint, it says plaintiff indicated to defendant she did not expect him to be involved in the rearing and support of the child and did not need to speak with her again if that is what he desired.
So which is it, Laura?
Was potentially intimidating or coercive language, it didn't work because the plaintiff alleges that despite those things that she did not expect from him, she proceeded. So on the face of the pleadings, assuming these facts are true, the claim fails. Furthermore, in section 39, there was a reference to, I'm sorry, I wrote the wrong number down. Defendant used verbally and emotionally abusive manipulations, even threatening to call the police if she hesitated in terminating the pregnancy. This was alleged by Mr. O'Dwyer as another potentially coercive or intimidating act. But if you read the prior sections of the complaint, in section 18, on July 28, 2021, plaintiff administered the first pill. On July 29th, she administered the second pill.
Watch Kyle's face. He's like listening to him lay it out Because he's only had
On
this
July
case for like
31st,
7
she
days, and he's like,
administered the second pill again. And so by the time we reached this allegation that he threatened to call the police if Miss Owens hesitated, she had already performed, induced, conducted, whatever verb you want to use. It had already happened. So that could not be coercive behavior that caused her to obtain an abortion. It was done.
Woodnick's smiling down there.
The things that happened prior, as pointed out in the motion and in argument, were promises to do things at most. We could have a relationship. I want to meet your family. Maybe in the future we could have a child. We're going to go on a trip, etc.
She'll try, I'm
Promises
sure.
to do things are not intimidating or coercion. No matter what definition you choose for those terms, that ain't it. There needs to be something that causes a person to act against their will. And that's not what occurred here on the face of the complaint. And so regardless of whether the court finds the statute to be constitutional or not, the complaint does not state a claim for which relief can be granted, even if we assume all of the pleaded facts are true. And for that reason, this abortion coercion claim, which is shorthand, I don't know how else to call it, must be dismissed.
All right, thank you. The court will take the matter under advisement and issue a ruling as soon as it is able to do so. We do have 60 days from today's date. We always endeavor to get it out just as soon as we can, and well under the 60 days.
You did.
But we obviously want to, as we always do, reread everything that's been filed, and then also continue with our case law research. So we will do that. So thank you, counsel, for your presentations this afternoon. I appreciate it very much. Anything else today from plaintiff?
No, thank you, Your Honor.
All right. From defense?
Very briefly, Your Honor, I know there's been some discussion in filings in this case about discovery and disclosure disputes. My hope is that now that Mr. O'Dwyer is involved, we can proceed with those things. But what is the court's preference if there is a discovery dispute? Do you prefer a motion is filed or that we call your JA, or how do you want us to do that if the issues are not resolved?
File a 2060 joint statement and we'll address it.
Okay, thank you.
Thank you. All right, anything else from defense then?
No, Your Honor.
Okay. All right, thank you, everyone. Please take care, be well, and
Okay. Okay,
you,
great, thanks. Well, I don't know about you guys, but I love nerdy arguments about, hypotheticals and stuff when it comes to the law. I find them very fascinating. Not everybody's thing. Now, a lot of you have been like, well, we know she's not even pregnant. We know that. And that's what the defense has been saying, the whole time, that she's faking everything. The reason why they're still talking about it and not acknowledging that is because the court hasn't ruled on that. And that's what they keep trying to get this ruling to be dismissed, and that she's faking everything. But the judge, for some reason, because we're over a year at this point, hasn't ruled shit. It's kind of interesting. Why? I don't know. I don't really know a whole lot about civil cases compared to criminal ones, but it's kind of weird. I don't understand why this case keeps going on the way it does. Like, just make a freaking decision already. But Laura's argument is like, well, I peed on a test and it was positive. Here's the proof that I'm pregnant. But we all know she takes the pregnancy hormone that I can't remember, GHB, right? No, I think that's a drug. Anyway, you know what I mean.
Yeah, but brain isn't working.
I was like, wait, GHB? There we go. It's like GHB. Pretty sure that's a date rape drug. That's not right.
Like, my brain is buffering. Sorry. That's what happens when you listen to Charlie Brown's dad talk for a while.
Right. So that's why, we all know she's not pregnant. The defense has been saying, like, listen, first of all, she has to be pregnant in the first place. And she wasn't. But they're just stuck in this situation for months of trying to get the case dismissed and a summary judgment. And it's just going back and forth, both sides just being like, well, you can't prove it. And that's just where they are for a very long time, which is very annoying. And I don't really quite understand that. But Anything else that makes sense? Because hey, CG, thank you guys. Thank you. As their arguments was the informed consent. What we do know, and actually we're going to learn about more on Thursday, is that Laura contacted this place on her own to get the pills. She had conversations with the nurse practitioners. Like, she was 100% informed. It's not, that part's not up for debate. I don't know how it could possibly be.
No doubt in my mind that it wasn't. Like, I don't.
Right.
Do you know how many people I have to talk to before I get medication? Like, even going to the pharmacy, it's like, and the pharmacist wants to talk to you. I'm like, we've only been taking this medicine for, I don't know, a year, but go ahead.
Yeah, it's like a really big deal to their jobs. Like, well, I wouldn't expect Laura to know what jobs are like, because, apparently she's never had one. But also then says she has tons of them. So either way, she doesn't know how jobs work or anything.
And then
how anything works.
Papers. The doctor tells you, the pharmacist tells you, and then they give you paperwork. It's on the box. I mean, okay.
But the argument of, well, Greg says he won't have anything to do with the kid or pay child support. Well, it's not really up to Greg. I mean, if somebody says, well, I'm not paying child support, it doesn't really matter because you take it to the state and like that's out of your control anyway. It's not they can say that all they want. And they can also not pay it even if the court orders. Ask me how I know. But that means nothing. All right. Lots of men say that. And I don't think that that's coercion.
But you're lucky if you can get a man to say that. Most time they just ghost you.
Oh, that's true. That's true. But even if he's like, I'm not going to have anything to do with the kid, blah, 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 I wouldn't consider that coercion. I mean, it's because it's just an everyday occurrence, and it is what it is. I don't know. The arguments are wild. That lawyer. So yeah, she hired Kyle on August 9th. That hearing was August 17th. So that guy has no idea what's going on. And, I wonder, because we don't know why Carrie, or was it Carrie or Casey? Hold on, what was her name? Carrie. We don't know why. Yeah, Carrie Ramos. That's right. Casey Bowman is with Woodnick. We don't know why she left Laura's case, because she doesn't have to say why. But it's interesting that she then hires Kyle. And I don't know if she hires any other women attorneys. But I wonder if perhaps she goes the male route because they don't know how things work,
Well, I mean, it was like you said, just watch his face. And it was like his eyes were just like, I should have probably done a little bit more depth reading on this before we got here.
Right? Like, ooh. Oh,
did you read all 40 of those documents? She had concerns about that.
Right. She didn't. She thought it took a long time for people to read. Mostly because she doesn't understand what any of them are saying. Yeah, she actually did. That's what we're going to be talking about on Thursday. And I'm very excited about it because we've had so many questions. Yeah, he wasn't even in her presence, according to her. It's like, so I don't understand how this case is even going as far as it is at this point. This is crazy. But
I can't believe it's gotten as far as it has already. I'll be honest with you. This started like in 2020, 2022. And this is like going into 2023. And it's just like, my ADD could never. I would be so bored already.
I mean, yeah.
I feel like this is too much work. I'm done.
That's why I just started summarizing, because the arguments were the same. I'm like, we've already been over. They're just going back and just. So I was like, fuck it, we're not reading. There's nothing new in any of these. But yeah, I mean, listen, most of us women who have heard what she said is immediately like, girl, that's not how our bodies work. But I think she goes for suckers that don't have any experience in those sorts of things. So after this, about 2 months later, October 21st, 2022, Arbitrator Devina L Jackson is assigned to the case. Now, I don't know why this happened. I read all the documents in between and nothing really gave it a reason. But again, it's kind of a civil case thing. And I think I've watched maybe 3 civil cases ever. So you don't really get in them.
It's an arbitrator. What is an arbitrator?
An arbitrator, because I looked it up, according to Webster's dictionary.
Oh, are we using Webster's?
I don't know. I Googled it. It was the definition, but it's probably Webster's. But since it's fine for a lawyer to do that, which was hilarious, by the way. Like,
I was like, are we not using legal dictionaries? Like,
right. What?
I mean,
so an arbitrator is a neutral third party chosen to resolve disputes outside of court by holding hearings, evaluating. Yes, basically. It's a civil mediator. But they can render a legal binding or non-binding decision. So they're basically like private judges.
okay.
I don't know why that's, necessary or important. But I mean, in family court,
So you don't
there's
tie
usually
up courts,
mediators.
I guess.
Yes,
Well,
but isn't
yeah.
it still
But mediator, I don't know. My mediation was done in a conference room.
It started
So,
in
not really in a
2021
courtroom.
BC before Clayton. Is that how we do the Laura Owens timeline? BC before Clayton, AC after Clayton. Greg is a master hacker. I love that. Judge Judy is an arbitrator, technically. Oh, interesting. Anyway, so it then gets moved to Devina L Jackson. And then they do another hearing, which we are going to watch. Ames, if you're listening. It's the 5-minute one. Oh, wait, no, I have that one. I got the one that you boosted for me, so hopefully that'll work. It's only 5 minutes, and I think this involves the arbitrator, so I don't think we're going to learn much, but whatever. It's only 5 minutes, so it's fine. There we go. Okay. And then we'll just get into some of the documents. So this hearing that we're about to watch is from November 15th, 2022. So, quite a few months since August. Now, what's interesting is that this hearing happens the same day that Laura files her protective order complaint against Greg, wanting a protection order. We read that last. Yes. Yeah. Okay. That we read. So this is the same day that she gets that and is granted that, apparently, which.
Oh, okay.
It's one of her many tactics. Well, things are going my way. So, oh my God, I can't wait till you, especially you, Buffy, see the crazy shit she gets ready to start doing. It's when she starts calling police. Oh my God, it's so funny. It's so funny. They're saying mean things about me on the internet.
Oh my God.
Even though it was I who outed myself on the internet. It's so funny. They do it because, text packet says they do it because arbitration is typically faster and a lot more private.
We know how. Laura loves her privacy.
That's right. Well, she wanted to see
her zone of privacy.
Her zone of privacy. All the documents should be private. How dare people? How dare people? Lainey says, what we watched today is the last hearing. Oh, no. This is not. We are still in the middle of Greg's case. There's so much more. Because spoiler alert, guess what? That hearing was pointless. This isn't a current case on trial now. Have her and Greg wrapped up? I know her and Clayton have. I know Michael Maricini gets his protective order dropped. Is Greg over as well? I don't know, because there was a certain point where I don't know anything on purpose. So you wish we were difficult to listen to so you could get work done. We're at just the tip. That's where we are, according to Barbecue Queen. We're just the tip. It's never just the tip. We'll probably go full thrusting starting next week. Let me tell you what.
Whew.
He's getting on here. No, what's the Mormons call that?
It's called. Why are we here? Why are we here? It's called soaking.
Soaking. We're just soaking right now. Oh, Steph. This is why people are like, we can't stand to listen to you guys.
And everybody just stopped watching.
Okay, thank you, Minnie. The judge dismissed both Greg's and Lo's cases. Okay. So, because things get real messy real fast. Remember, she ends up getting felony charges for Greg's case. 7 to be exact. So, so even if they are caught up, it is worth still going through because I find it fascinating. And we still have more to cover today. But to watch her, how far so like already she has elevated since she went after Michael Maricini first. Like how she is clearly evolving with everything that's filed, with every hearing of, and she's about to get so bad shit crazy.
About to.
I know. That's why it's fascinating. But all right, let's watch this 5-minute hearing real quick, and then we'll get into our next documents. Maybe if you share this tab, Llama, that's what you're supposed to do. Again, only 5 minutes. It should be good volume-wise. This is the one that you already boosted, Amy, so it should be the same.
Go ahead and call your matter now. This is FN 2022 052111.
Wait,
Laura.
Why is there no people? Let me refresh. I think that's amazing.
We are professionals.
We are
Just a reminder.
Professionals-ish.
It was sarcasm.
Okay. All right. We are now at that stage. Okay. So just 5 minutes. This is with, I don't know.
I'm going to go ahead and call your matter now. This is FN 2022 052111. Laura Owens and Gregory Gillespie. Ma'am, would you say your full name for me, please?
Yes, it's Laura Owens.
And would you please raise your right hand so that you can be sworn in by the court?
Yes.
You do solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can put your hand down. Now, you are the plaintiff in this matter. Who is Gregory Gillespie to you?
He is an ex.
Okay.
I currently am involved in litigation with him as well.
I just needed to make sure you had some sort of relationship with him. So he is an ex-boyfriend. I did have an opportunity to review your petition, and you are alleging that he's made multiple attempts to contact you despite an active order of protection. Is that correct?
Correct.
Based on the evidence presented, then the court finds reasonable cause to believe that the defendant may commit an act of domestic violence or has committed an act of domestic violence within the last 12 months. Therefore, I'm granting the request for the order of protection and entering the following orders. I will order that Mr. Gillespie not commit any new crimes against you. I will order that he have no contact with you and you do not want any exceptions, correct?
Correct.
I will order that he not go on or near the residence listed. Does he know where you live or do I need to hide the address?
He does know where I live and I do plan on moving.
Okay. If you move and your address is changed, you need to request a modified order to reflect that new information, okay?
Okay.
You work from home, so there's no other work address to protect?
No. I have animals on the property though, and that's why I put the animals.
Okay. The defendant is ordered to stay away from animal kept or held by petitioner, defendant, or minor child who lives in either the petitioner's household or the defendant's
this is her protective order hearing.
I am also including your request. Defendant not be permitted to contact you via text message under pseudonyms. Request defendant not be able to watch videos on social media under his name or pseudonym to attempt to determine your whereabouts. I will include that in the order as well, okay?
Thank you so much. I
You're welcome.
really appreciate this.
Now, the order of protection does not go in effect until it is served. It will be served by a sheriff's officer as soon as possible. I don't have any control over when they serve it. I do have control over when the sheriff becomes aware of it. We usually let the sheriff know on the same day the order is issued that it needs to be served. But if you need me to, I can wait to let them know up to 72 hours. You want me to let them know today as we normally would, or do you need me to wait?
I would like for you to let them know now. Thank you.
We will notify them today. They'll serve it as soon as possible. Once it's served, it's valid for 2 years. If any of the information changes, you must request a modified order to reflect the new information. The order of protection does not substitute for any other matters you might resolve in Superior Court. Today, you'll get copies of the order as well as the petition. Keep a copy of the order with you at all times and make extra copies. If he shows up and he hasn't been served yet, you can call the police. Let them know that you do have an order of protection that needs to be served. If they're willing, they can come, take one of your copies, use it to serve him, and then it would go into effect. He does have a right to request one hearing anytime while the order is in effect. So if you move or change your telephone number, be sure to notify the court. That applies even if the address is protected. If you request a hearing, the court will attempt to notify you at your last known address and phone number. And if he shows up for the hearing but you do not, the order will be dismissed. Once the order is served, it's a crime to violate it. Always notify the police if you believe he's violated the order in any way. Call the police in the city that the violation occurred in. The order of protection does not guarantee your safety, so you should take steps to keep yourself safe. That would include giving a copy of the order to the entities listed on it. Do you have any questions for me, ma'am?
Do I need to notify the court in the other case that the order is in effect, or is it just different?
That's up to you, ma'am. I can't give you any legal advice. So if you have an attorney in that matter, you can talk to the attorney or you can contact the court.
Okay, I just didn't know if it was a requirement or anything. Okay.
There's no requirement.
I appreciate it. Okay.
We're going to email this over to you in the next half an hour or so. Make sure you print multiple copies once you get yours, okay?
Okay, thank you so much. Have a
You're
great
welcome,
rest of your
ma'am.
day.
Thank you. You too. Bye-bye.
Thank you.
She sucks. Laura sucks.
It always
Lainey.
cracks me up whenever they say, I order Mr. Gillespie or insert random name not to commit any new crimes. I'm like,
Okay.
does that really need to be said?
I missed the pet part because I had to go to the bathroom and I can't. Because I saw she was granted because of a pet, but it didn't say in the paperwork. What was her argument about animals?
She's just worried about her animals on the property.
That Greg's going to hurt her animals? Okay.
Yeah.
Okay. Now, Lainey.
Say buttons.
Say buttons. Where's Buttons? Is Buttons still alive? Probably not. Clayton's case was the first to, well, that's family court. Because she's an idiot. But his does kind of bring things into the spotlight because he was on reality TV, so he's more well known than Greg or Mike. But we started with Mike. Now there is another guy or two. I know one that does not want anything to do with any of this and doesn't want to talk about it, and I think that's just fine. You know, any victims that don't want to talk about what they went through, I respect that, and that's fine. So we won't mention who he is, but there was somebody else. But we started with Michael Maricini, which is pretty much kind of the beginning of this, and then it goes to Greg, and then she gets balls in everything we've discussed here already, and is like, I'm going to get me Clayton. I'm going to get me a celebrity, and I'm going to do the same thing, except take him to family court, by the way. Not even civil lawsuit, like family court. So it gets crazy. Oh, that's the one I meant to answer with that one. So I really hope she'll be held accountable too. At the end of April, she's supposed to decide if she's going to take that plea deal or not. I don't think she's gonna. I will be very, very surprised. Or she might take it and then do what Devin Michaels did when it's sentencing time and try to take it back and be like, no, I was forced. I was intimidated and coerced to make this decision. My lawyer kept staring at me.
I didn't even think about that as an option.
I could see her doing it. I mean, everything.
I mean, I can see it, but I honestly didn't even think about that. I was like, oh, that's
yeah,
that would be right on, like, that would track.
Yeah.
I was coerced into making that plea deal.
Because they literally ask you that, though, verbatim. Like, when you plead guilty, were you coerced into doing it?
Forced, yeah, whatever.
And we know how Laura fucking feels about promises.
Oh.
I have never met anybody that takes promises so well. I mean, they should be taken seriously, but like, girl.
Well, judges don't always actually have to conform to the plea deal, correct? Right?
That's
like,
right.
It can be.
They can do whatever they want.
The judge can be like, yeah,
Reject
I'm not following that. I'm doing what I want. Exactly. That's what I'm saying. Like, can you see her being like, Your Honor, but y'all made promises.
Right? But like, everybody made me promises. But you said though. Now, okay, so that wraps up 2022 for Greg's case for that year. And now we're going to be entering the year 2023. And this year is a very busy and bold year for Laura. As I've been saying all morning, shit gets crazy and way more unhinged. I mean, it's one of those cases where you're like, to say it gets crazy, you can't even comprehend how it gets. A reasonable person can't anyway. But the first part of, it's train time. The first part of 2023 is actually rather slow. It starts off with the end of the Lone Cactus lawsuit, which we already covered in a previous case. Because remember, that was going on the same time as Gillespie. She was in 2 court cases. So that one wraps up out of the way. All right. And then she's still on with with Greg Gillespie. Then this is what you guys have to look forward to for 2023. Are you ready? So she's in court with Greg. Then she gets into family court with Clayton. Because you guys, she's pregnant again with twins by performing a blowjob, apparently. So yeah. I mean, Greg and her did have, sex. But nope, she's bold. And she's like, I'm going to try this again. Except go to family court and ask for a parenting plan. Oh, God. Anyway, it's crazy. There's also going to be a lot of Laura calling the police about harassment. And they're like, we get to hear phone calls of her calling the police, which is great. And then Laura writes a bunch of ridiculous Medium blog posts, including basically outing herself as the anonymous woman in a relationship with Clayton, like an idiot.
Really? Like we have a Dear Diary.
Oh my gosh! Yes, Buffy. Yes, yes. We have lots of blogs, and they're wild. I have read a few of those, and not only does she have some, but later her Gingras, whatever the fuck his name is, he still blogs about this shit too. They're crazy, just crazy. How long between Greg and Clayton? Well, she met Greg in 2021, and then Clayton comes in 2023, so about 2 years. Her new lawyer specializes in negotiating plea deals. He's probably seen that before. Right. Are you pleading guilty because you are guilty? Yeah, I don't think she's gonna.
Yeah, that's what I don't know if she can physically do that. Like, she would have to admit, I don't want her to take the plea deal just because I need to be entertained by this trial.
I do too. I need her bullshit even more public. Okay. Because
purely
listen,
selfish reasons.
She's not, well, it's a public service announcement at this point. You think that if she doesn't get put in prison, she's not going to try to do this again.
Oh,
I mean, she probably
100%.
will even out of prison, but like, everybody needs to know about this because she is going to continue this behavior. It's a pattern. It's compulsive.
The security guards better be careful. Correction officers.
If a guy stares at her, she's suddenly pregnant with quadruplets. So the whole world needs to know about her craziness. But whoo boy. Also, so then she writes all these Medium blog articles that I can't wait to read. And then Clayton sues Laura. All right. As she's doing this paternity thing, he files a civil lawsuit against her. So they have an extra court that they go to as well. And then Laura decides she doesn't like what people are saying on the internet or on YouTube. Yeah. So then she
tries, my feelings too, bestie.
She tries to get, I think, a protective order against Dave Neal, the YouTube content creator, who's been around with this since like the beginning. All right. But she tries to get him involved in all of this. Then she tries to change her name. Then we have phone recordings, hearings, body cams. Oh my. And then I'm pretty sure that that's when her attorney Gingras comes into the picture. And then we'll have his crazy blog post as well. And who else knows what other crazy? And this is just 2023, you guys. That's just, yeah. When I say she ramps up, all of that is in a matter of like 4 months.
Llama.
Yeah.
It is 2026.
I know.
And we are still here.
I know. But like, it's wild.
Like, that's just 2023. I'm like, Jesus, still 3 years to go.
Well, it's just half of 2023 because nothing really happens with Owens.
Is she bored?
I think so. I can't wrap my head around this way of thinking. I can't. I don't even know what it is. It would be poster size. I need a billboard, Kelly. All right. Your shenanigans are out of control. But so for the first half of 2023, not much happens in the first half regarding Owens and Gillespie because they're preparing for the arbitration hearing or trial, whatever you want to call it. That's supposed to be in August. So there's a whole lot of nothing going on. So maybe you're right. Maybe she was bored.
It seems like she's bored. Just seems like she's bored.
Right. I don't see how she gets through a colloquy and accepts responsibility during a guilty plea hearing. Yeah. I don't think it's going to happen either. I remember it was Easter weekend when Gingras joined the case. Now it's Easter weekend 2 years later. So he'll be coming in fairly soon. So if she repeatedly takes men to court for the same reasons, making up lies, which is criminal illegal, so is bringing frivolous lawsuits that all has to be admitted is actions, not behavior. Well, she has 14 felony counts for this bullshit, for identity theft, fraud, and perjury. Charges both for Clayton's case and charges from her case with Greg. So she fucked around and found out is all I'm saying. And she's in even more trouble than just that. It's beautiful to see, really. Yeah, she has bankruptcy filings. The government's on her ass, which is not good. You don't want to do that. So anyway, so the only thing that they have going on, and this is where I need your help, chat, because I didn't want to Google too much and get spoilers for myself. But let me pull it up. This one here. Okay, so this was filed. Let me blow it up for y'all. Doop. This was filed on February 16th, 2023. And this is where I got confused. I'm guessing he must come back, but I don't remember when or how. But this is an amended motion to withdraw as attorney for Greg. So Woodnick is cutting ties. And why does this happen? You guys tell me why this happens. Because it doesn't really say. Well, it does. So this is saying that Woodnick Law is withdrawing as attorneys for Greg, and that the reason for this breakdown in communication between attorney and client has occurred such that the attorney cannot proceed with client's representation. The client has failed to substantially to fulfill an obligation to the lawyer regarding the lawyer's services and has been given reasonable warning that the lawyer will withdraw, and withdrawal can be accomplished without material adverse effects on the client. Is that because he couldn't afford to pay them anymore? Is that why?
It sounds like that, but I think what I heard in that podcast was that they withdrew because of the allegations that she made.
Oh, the rape the conspiracy.
Yeah. Because they decided to distance themselves from Greg. That's what the podcast said.
Oh, the Love Trapped one that I saw.
Yes.
Because I don't have the time.
Said they decided to separate from that. And then I think he ends up coming back. It was safer to separate. Like, it's like text. Like, it was just not a good thing for him to be. Yeah. Anyways, because they did an interview with Woodnick on the podcast.
Oh, okay.
And he said that was one of the reasons why they. But I do think he does come back.
I know he comes back. I just don't remember like when. I didn't even know that he left Greg. So I was very surprised, and I didn't see that was really the only reason I saw why. And I was even confused about that. I mean, now if it was because he couldn't pay, I mean, that's why this is such bullshit of Laura, is because it takes a lot of money to retain a lawyer that a lot of people don't have. I mean, billable hours is quite literally insane, to be honest with you. So, and this has gone on for so long, I could easily see him, losing money and not being able to do that. So, it was mutually acceptable for all. Okay. That's, as Clayton said, this is from Bill, one of the conditions should be to declare her a fictitious litigant so she can't continue doing this after the criminal case is over. Can they do that?
Yeah, they absolutely can. If you're one of those people that file like ridiculously or weaponize the courts, they can make it to where you can't just sue people anymore.
I love that. I agree. It should be that. Pardon just a second. My dog.
There's a certain YouTuber that has happened to.
Oh, was he? Is that interesting? I'll be right back.
Hi. Yeah. So that's definitely a thing. Yeah, I had to stop getting too far in the podcast because it is so interesting that like I was getting too far ahead. And I didn't want to like keep ruining it for myself. But I did hear that episode. So I was able to answer a question. I'm pretty proud of me as to why like he pulled out of that. So.
Okay. Sorry. Zoe just finally woke up today and, so now Greg, Woodnick Law, all of those people involved have withdrew, from representing Greg. So that's in February. Now they're still supposed to have this arbitration hearing in August. So then it is July 21st. So about a month before they're supposed to have this arbitration hearing. Attorneys Fabian Zazuta, which is a great name, and Garrett Respondek, also a great name, of Zazuta Law, starts representing Greg. So now Greg is going to have new attorneys.
Sad face.
I know. Definitely sad face. But don't worry. Woodnick does come back at some point, and he is sassy. Super sassy.
I know when I heard that on the podcast, I was like, dude, you just gave her what she wanted. That's exactly why she said what she said. She was
exactly.
Trying to get why would you do that?
Exactly.
I mean, I get it. I understand, but I don't agree.
Right. Hi, IB. Hello. Welcome. All right. So the next document that they do, it's 19 pages. We're not reading it all because it's a 3-in-1 document. It's the plaintiffs filed this. Kyle is still representing Laura at this point, which is now almost a year from that hearing that we had listened to, the 1 hour one. And so I don't know what they've been doing this whole time, but so first part of it is them filing for a partial summary judgment of all of defendants' counterclaims. There's nothing crazy in this at all. The title says it all, and it's mostly case law. All right, so they're just asking for a partial summary, meaning cancel all of the defendants' counterclaims is what they're asking for. It's super boring, and that's literally it. And we've been over the same stuff a billion times already for a year and a half. So we are just going to skip all that. And most of it also, I didn't watch the hearing before we watched it, but it's pretty much all the same arguments from there. So in this, though, is the plaintiff's statement of facts supporting her motion for partial summary judgment. Same thing, saying defense has no proof of accusations or damages, and they shouldn't be given anything. We've already read several of those documents. It's all the same information. Nobody cares. So then they include this as Exhibit A, which is a filing from the defense. This is from when Woodnick was on the case. But I don't know when this was filed because it wasn't attached to anything, and it wasn't in my list. So I'm a little confused about this. But this is defendant's counterclaim of Gregory Gillespie's second supplemental rule 26.1 disclosure statement. So this is basically a look into what they plan on using for that hearing / trial, whatever you want to call it. So we are going to read this. It's very quick because there is some new developments in here. I don't know when it was filed. So let's take a look at this. This isn't that many pages. Oh gosh, you guys type so fast. Yeah, that's all very understandable. That makes a lot of sense now. I hate that she gets away with bullshit sometimes. I really, really do. So, all right. So pursuant to this rule, they're going to give everything that they plan to use or could use for the hearing, right? So factual bases of defense and counterclaims. So see their motion to dismiss filed in September 2021. So way back in the day, and the answer, all that stuff, right? In addition, and critically notable, Laura has reportedly fabricated a pregnancy and subsequent abortion in the past during a relationship with Michael Maricini in 2016. So yeah, so this would have been filed at the end of the year before Woodnick quit. And they have now found out about what happened to Michael Maricini. How they found out, we don't know. But I mean, you could just like find a case. It's not like that secret or anything. But in Buff, you listened to the interview Michael had with Megan Fox too, right? Didn't he say that for Greg's case that they had reached out to him, but he didn't get back in contact with anybody until after Clayton, right?
I don't remember.
I think that's what he said. So
I don't remember.
I'm trying to do my taxes on TurboTax while listening to this, or as Laura calls it, Credit Karma. Well, I believe that that's what happened is they do reach out to Michael, but he doesn't really want anything to do with it at the time. And that he like left it sitting in his inbox for a while until he found out the stuff with Clayton. But anyway, so they're bringing proof like, something similar seems to have occurred here. And I see that's the thing is they had to know about it because in all of her emails, she's like co-host of the most popular podcast with my mom ever and the most popular TEDx talker on the internet. So, I mean, it's not really that hard to put the pieces together.
That's how I sign off most of my emails now. Incredibly difficult to listen to podcast co-host.
Yes. I should put that as my sign off as well. Even though I don't email anybody.
I mean, I just want to email everybody so that everybody can read that on the bottom of my emails. Anyway.
Yeah, he was afraid of her still in that argument. I mean, who would it be? That's why, that's why we wanted to cover this too, just because let's get the word out about Laura. Because again, I don't think she's ever going to stop at all. Oh, speaking of, Laura Owens has entered the chat. Also, somebody in our comments called her Laura Blowens. And I died. I don't remember the name of the person that left that comment. But I was like,
so funny.
In regards to Clay, I mean, it's just the jokes write themselves. And listen, she's a horrible person, clearly. So do I embed trackers in your emails? I don't, but if somebody embeds trackers and they send me an email, it's going to say unread for numerous years. I am the worst.
I'm going to have to start checking your emails for you, aren't I?
Probably.
Okay.
Don says, I'm pretty sure that Greg is refusing to participate in Love Trap because he has had that restraining order still and doesn't want her to claim he violated online. Oh, that's it. Okay. Could be. That makes sense. I mean, when we hear all of her police calls about they're harassing me online, welcome to the club, sister. That's what happens. Bill says, I think Woodnick said he'd help secure these new attorneys for Greg. Oh, that makes that I could see that happening. Usually lawyers will help you do that. Oh, no. You helped find the Hydra spy. Oh, no. All right. So let's get back to this real quick. So here's the names and addresses and telephone numbers of everyone that they plan to call for trial, the defense, right? So there's Greg. They say Mr. Gillespie is expected to testify regarding the extent of his relationship with Laura, all communications with Laura, and the emotional distress and monetary damages he had suffered as a result. They're also planning on calling Laura, where Laura is expected to testify regarding her allegations against Greg and the alleged damages she has suffered as a result, including Laura's current and former medical providers. Any other witness found to have relevant information regarding the subject matter of this lawsuit, like her mom, probably. And in the absence of an agreement with the admissibility of documents, any and all custodians of records and any other witnesses required to authenticate or here's persons whom the defendant counterclaim believes may have knowledge of information relevant to the events. And that would be Uncle Joe Cotchett, Allison Cordova, Tony Stevens, and Patrice O'Malley are believed to have knowledge on information regarding Laura's seemingly fraudulent emails purportedly authored by Uncle Joe, and lawyers that have not worked for the firm in some time. Though she now comes back and says, no, those are fake. I didn't do them, but Greg did because he's a hacker, and so they just made this all up, including his attorney. I didn't do anything wrong. I would never do that. Like, oh, okay, girl, that doesn't even make sense. Oh, was that you, Dawn, with the blow-ins comment? Well, you got me, girl. That was good. That was good. Greg said he wouldn't participate in the podcast until she's behind bars. Can't blame you there. I mean, she's gotten away with a lot in the courts at this point, to be quite frank. I would be nervous, too, of whether or not she's going to get proper, consequences for her actions here. Let's see. And then, Michael Maricini's on this list. Is believed to have knowledge or information regarding allegations Laura lodged against him in the past and alleged emotional distress and damages Laura allegedly sustained as a result. And Laura's admissions regarding her fabrication of a pregnancy and subsequent abortion during their relationship in 2016. I wonder, what I wouldn't have loved to be in the room where it happened when they found out about Michael Maricini. Like, they would have been like, oh, what? This is crazy.
Yeah. Can you see everybody's face? Like, stop it. Probably much like mine last week.
And then these names that are blocked out here, I'm pretty sure are Michael's sister and then her boyfriend, Colin, based on the first initials. That kind of makes sense. But they're also believed to have knowledge or information regarding allegations Laura lodged against Michael Maricini and Laura's admissions regarding her fabrication of a pregnancy and subsequent abortion during her relationship with Michael Maricini in 26. Because remember, she does admit to that. She does say, "Oh, it wasn't real," because she's obviously Laura's family members, including but not limited to her dad, her mom, her sister, and her sister's husband, I think, is CN, who may have knowledge of information relevant to that, and anyone else they want to call. And then people have given written statements for Michael's case, which we read all of those. They don't list any expert testimony yet, but that they reserve the right to. That they believe Greg has sustained significant monetary damages as a result of being unable to work due to the extreme amount of emotional distress he experienced while being subjected to Laura's fraudulent representations and intentional infliction of emotional distress, and is therefore seeking to be compensated for the same, in addition to an award of his attorney fees and costs. Oh, hold on, let my dog in real quick. Just a second. Come on. Are you getting out there, Tia? Or are you coming in? Okay. Sorry. I don't know why the dogs don't want to just stay outside today. It's a beautiful day here. It's 76 and partially sunny, and it's nice. This is why Ella threw such a fit when Michael showed up to testify in Clayton's case and tries to send him straight to jail. Doesn't she try to do that with Greg too? Oh, God, can't wait. So the exhibits they plan on calling text messages between Laura and submitting between Laura and Greg, communications between Laura's work phone. Remember, Miss, I never had a job in my life. I don't know how that works. And Greg's cell phone. Communications between Laura's email and Greg's cell phone. Communications between Laura and her AOL email and Greg's cell phone. Communications between Laura and Greg's cell phone. Again, more of that. Another email address, I guess, of Laura's to his cell phone. And more of that, blah, blah, blah. A letter from Laura to Mr. Gillespie. I think that might be the one like, we can still date if I will drop this whole case if you date me. Because that's literally what she said to him in an email. I will drop this with prejudice, meaning you can't bring it up again, if you agree to date me. Now, I don't know if that's intimidation or coercion, but it sure sounds like it to me.
It sounds like coercion to me.
Sure does, doesn't it? I mean, even intimidation, right? Because it's going to cost him a lot of money to keep doing this. So,
yep. Or extortion, coercion.
So then the email from Laura to Greg regarding urgent copy of conversation with Joe, which she says it was Greg. Greg did it. Laura's Instagram post. Laura to the attorneys. Complaint on damages. Wait a second. Is this from her her Uber case? Complaint for damages based upon negligent entrustment, negligent hiring, supervision, or retention of the case. I think that's her Uber lawsuit. Maybe not. Oh, they're going to bring up the vanishing blog post where she stole the ultrasound of a grieving mother because she's an asshole.
Yeah, that's
disgusting. She should go to jail for that. Which, by the way, one of the charges is literally for that. if I do recall. And there's the link for her stupid TED Talks that she does, which is ridiculous.
The life-saving power of kindness to strangers.
They sent me a napkin because it was awful. Even though, if it was that bad on there, all right, if he was yelling at her and treating her there that everybody could hear it, wouldn't there be like marshals on the plane or something? Like, wouldn't something have been done or said about it?
Those
to them?
Stewardess, flight attendant
Yeah.
would have been all over that.
I would think so too, because that's a long flight. Because they were going to Iceland from California, so somebody would have said something, but yeah, she did not call the police.
I'm just saying, there would have been somebody with their cell phone out videotaping that.
Right?
Saying it didn't happen, but just saying, I've seen some crazy flight videos on the TikTokies.
Yeah, Laura pisses me off so much because she takes everyone else's real trauma experiences and then tries to claim the same thing. And it's just so fucking disrespectful. And she's disgusting. And I do not like her for it. And I will never forgive her for these things. I mean, it's already disgusting what she does to these guys. But then to be like, I'm an advocate for DV when it never fucking happened to her. Oh, I'm a victim of, abortion, blah, 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 blah. And none of it's real. And I hate people that are like that.
Allegedly,
so much.
in our opinion.
Allegedly, in our opinion. I mean, I don't allegedly hate her. I don't like her.
No. The other parts, the stuff that could.
Oh,
yeah.
Right. Well, I mean,
allegedly, in our opinion.
I don't see any, domestic violence, criminal charges anywhere, but okay. So then also her medical records, blah, 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 blah. And then that's about it. That's all they have to say in that. So they are gearing up to, this was filed on March 4th, 2022. That's weird. Why wasn't it in my initial list? So that's just who they plan on calling if and when they go. Granted, Woodnick's not representing him at this point, but his lawyers that he did hire would probably keep the same flow of people and information. So it's pretty much the same thing. And then that's all we are going to talk about today regarding that, because the next stuff is just too long. There's no way we can fit it into 45 minutes. And I really do. Stolen valor. It's like that. It is like that, right? I don't know if that's the same wording to use, but yeah, it's vile, Ugh. Blah. Oh, Dan Montana says the flight attendant did talk to them. It was a red eye. And Lo was having a hissy fit and disrupting people sleeping. Oh, okay. You're a victim.
It was Laura who was having the hissy fit, not Greg.
Yeah, I guess so.
Imagine that. Allegedly. Reportedly.
Right. Now, good news is that, as I said, we're getting very close to, because that was filed in July 2026. Now, she goes after Clayton. I'm sorry, July 2023. It is also in July 2023 when she files shit against Clayton. So we are at the merging point. But Thursday, we're just going to stick with Greg's real quick, because this is something that we have had a lot of thoughts about and a lot of questions about, and I kind of avoided looking up. And then when I saw this was in the exhibits, I was like, oh, this is going to be very exciting. And I do hope you can make it Thursday, Buff, since you do have, some medical knowledge. So Thursday, what we're going to be covering is Greg's team files for another summary judgment, as they do, but gives us new exhibits. Okay. And we've had a lot of questions about Laura's medicinal abortion, if you will, right? And her experience, and how do you take the pills out of order? Like, what even is happening? Yeah. And we're going to read how it's supposed to work. because you know how you just said when you're given new medicine, you're given a whole,
Yeah.
all of that information. Well, guess what was submitted to the court? All of the exact information that she was given from the company.
Oh.
So we're going to learn how it works.
Oh.
So it's going to be like Couch Court with Llama, but also Llama learns about. I'm very excited about that. And then we get to read her dumbass text conversations with the nurse practitioner. Buffy, it's hilarious. It's so funny.
So you're saying I need to bribe my daughter for Thursday?
Yes, I would if I were you. You're going to be like, what? What?
Taking up a collection.
And so I'd like to get into that before we get into Clayton's case, just to get out of the way, because we've talked about it a lot. And it's the company that she got the pills from.
Mm-hmm.
So that's why I really want to kind of
She
read
ordered
it. So,
abortion pills online?
yes. From a company that I don't know how to pronounce yet because I haven't looked up how to say their name, but their name is kind of weird. But it's the information she received from them, along with the nurse practitioner that you have to like keep in contact with when you're going through it, So, oh boy.
I guess you can order early anything off the internet, so I shouldn't be surprised. But
yeah. So that is definitely what we're going to be covering on Thursday. I'm not going to be able to do a show this Friday or the Friday after because little Llama is flying out to Arizona, not to stay in Laura's casita. Okay. That's not happening. He's going to visit his grandma.
You'll be a grandma.
But his airport stuff is all during the day, so I can't be here for that. So, but then the week after, we're going to be stepping right into Clayton and Greg at the same time. It'll be very, very interesting. Because as I was looking at stuff there, you can't talk about one without the other, because everything starts merging together, including, stuff that Greg's, side is going to argue in his case with Laura, which will be stuff that Clayton argues from that in his case. So it's going to be a little back and forth, but I'll try to make it as easy to follow along as possible. So that is what we'll be talking about Thursday. Anything we want to talk about of what we've covered today? I'm kind of over there not being decisions made. I don't understand why decisions aren't being made.
I think it's just civil lawsuits are so slow.
But see, I wonder too. So they switched to an arbitrator, and those that have been following the case, I don't know if you know this or not, but you probably do, or at least can inform us, is I wonder, since they switched to the arbitrator, if like the documents weren't filed like the public ones would be, or what? You know what I mean?
But wouldn't there still have to be motions filed to go before the arbitrator?
I would think so. But there's like not jack shit
from I don't really know.
June to July. So, but as I said, everything I listed earlier about 2023 all happens from July to December. So the first half of 2023, boring, nothing is happening, and then everything is happening. And I'm so excited to finally get there. So, and I don't think, she's going to get some new lawyers. I don't know how long Kyle sticks around. I'm surprised he lasted almost a whole year, to be quite honest with you.
Poor Kyle.
Poor Kyle, right?
Yeah, no idea what he was so glad when he got fired.
Probably. Does she report him to the bar? She literally reports everyone to the bar too. This woman. Didn't she? Chad, didn't she? Her newest lawyer, not newest felony lawyer, but first felony lawyer. Didn't she report him to the bar as well, or something like that? She's always doing that shit. It's crazy. Arbitration is private. Oops, sorry. Stuck on my. Is a private contractual process rather than a public state-run one. So is that why? Okay. Well, either way. I
still need the documents.
I know, right?
either way, that's really all we have to talk about today. And really, we're just going to be moving at a very much faster pace from now on. Well, I don't want to say faster pace, just a lot of crazy stuff to read, because she does go, I believe with Clayton, she starts off pro se as well for a while. So that's fun. In family court. So she's got so many bar complaints, it's hard to keep track, right? Okay, so yes, that is why it's not filed. Okay.
I want to sit down and have a talk with her. Just want to talk. Like, really just want to talk. Not in this saying. I just want to talk. I have questions. I could pretend to be her friend for a little while. See,
I think you could.
Questions.
This would just be my face the whole time. Like,
I mean, I might be able to fake it. My face would be really hard.
We got those faces, boo. I don't know.
It might be a little hard.
You have a great day, Ivy.
If I pretend to be her friend.
She doesn't know how to friend. No, I don't think she does. And like, listen, I do try to find empathy for a lot of people, but Laura has lost all of it because of all of the shenanigans and bullshit she does. But even that, it's like hard to find anything remotely empathetic about her situation. No, none whatsoever. So, takes out. I just want to
talk. No, that's why I said it in the most genuine way. I just want to talk.
Do all be and Melissa Jade. I thought I saw a llama name. Oh, not me. No, I know Melissa Jade covers this. I just haven't had the opportunity to watch any of her coverage. I wish I had more time so I can watch all the other people who talk about this as well. I'm familiar who she is because I've seen it on the Justice for Clayton subreddit. Unfortunately, I have not been able to catch any of her stuff. So that is not me. It's a different kind of llama, but not me. So, and put it on camera. No, I don't think she would answer anybody's questions.
I have to sign an NDA to be her friend.
Other llama then. I am not a drama llama. So if you see not a drama llama, that is me on YouTube. Nobody else can take that one. So that's my that's why I'm called llama.
And sometimes have stupid things to say in people's chats.
That's true. Buffy is in a lot of chats. You'll see her up all over the place.
And then I have to watch myself because I was like, these people are going to come back to haunt me and what I'm saying in other chats.
Yeah, I don't usually get to be in chats because if I am listening to something on YouTube, I'm usually have it on my TV while I'm like working and writing on stuff, so but I'm gonna have a lot more free time to catch up on everyone. Oh, you're gonna go clean your casita? Where are you gonna put all those domino boxes, girl?
Throw away those voodoo dolls while you're at it.
Right. So you guys, our replay crew, if you're watching, feel free to leave comments.
If you're still watching,
you're still
at this point, you are a real one.
Right. Thank you. But let us know what you think about what we talked about today or something you want us to look at. We do make a list of things to make sure that we keep an eye on when we get to certain parts in the future. So yeah, feel free to, leave a comment, share on socials. Again, if you're pretty new to this, we have covered a lot up until now and have a whole playlist for you to catch up on. And I do see a lot of you catching up on old stuff and leaving comments, which is very cute and awesome. And I love that.
Please like the stream.
She'd be pregnant with triplets next time. See, this is the thing is if you wanted to be pregnant so bad, which she doesn't, because there are plenty of ways you can get pregnant without having a boyfriend or a man or anything like that. And it is not about wanting to have a baby. It's about trapping a man to date her. And then, because it just doesn't make any sense. And you don't have to go to IVF.
You get a boyfriend?
I know, right? He's just not that into you, Laura.
How do you do that?
Right. Now, tonight we're doing our second to last episode of True Crime and Wine Time's Frozen Baker or Frozen Fear, the Butcher Baker of Alaska, Robert Hansen series. Oh, it's going to be great. It's going to be great. It's confession time from him. So I'm very excited. I'll be doing that at 8 p.m. Eastern. We also had new merch drop in our shop at tcwtmedia.com. Not sure what all dropped. I should probably look. I just made a note to talk about it. Let's see. We'll just look together. How about we do that real quick before we go? Because you know what? Nothing's better than window shopping with friends. At least I think anyway. Okay. All right. Well, maybe not, but that's okay. Share this tab instead. There we go. Anyway, over at tcwtmedia.com, there's all sorts of fun things we have. I know we have, we have this cute little mug. Let me see. It's my llama mug. It says marked safe from Laura Owens. It's very cute, very cute. And I know we're going to be dropping a coloring book. That's actually like us, me and Terry, and like some, cases we've covered and fun things like that. So I'm very excited about that. So make sure you visit our shop, tcwtmedia.com, and you can get some merch there. And it's very cute. But other than that, that's all I really got for us today, kiddos. The real hero is Greg's wife because she told Clayton about Greg. Oh, interesting. Interesting. I mean, honestly, well, wasn't Mike's wife also like that? She seems amazing too. Thank God these men have met real amazing women, Laura, who didn't try to trap them after 2 dates. They were just reasonable women. So that'll be interesting. Is your Buckle Up Buttercup class there? Oh, I don't know if she's uploaded it yet. Terry does all this stuff, so I don't know. I sometimes pay attention. Hold on, let me see. I'm not the best at that sort of stuff. No, I don't think she's put it up yet. Either that or I'm looking in the wrong place. Probably me. It's probably a me thing. Find the Megan, Mike, and wife interview. Yes, that's right, because you all told me there was a second one, because I only watched the one with Michael and Megan, and apparently there's one with his wife as well. Yeah. So yeah, we'll have to watch that. But other than that, I will see you guys all reasonable women. Okay. No, I'm just kidding.
I want that on a shirt.
Oh, she did say it's not up yet. That's my bad. I just work here. Anyway, I hope you all have a great rest of the day. And until Thursday, 11 a.m. Eastern, we'll be back. But until then, go forth and be amazing. Okay, anything you say, Buff?
Just make sure you like the stream.
Yeah. And comment and share and all that fun stuff. All right? Well, you guys go have an amazing day, and we'll see you then. Bye, guys.
Bye.